Hi, my name is Dan Couvrette. I'm the publisher of Divorce Magazine, and I want to welcome you to our Divorce School session for today. I have the pleasure of speaking with John Grubb, who's a family law attorney with an MBA in accounting and finance, and he's the founder of a leading law firm for high-asset divorce in Houston, Texas. And John helps business professionals secure assets, property, and income while making fair arrangements for child custody and child support. And today, John and I are going to be talking about high net worth divorce. And just before we get started, I've known John for many years, and I can attest to his high credentials in the area of divorce and in finance, and also he's one of the most highly recommended family lawyers in Houston and in Texas. So it's a pleasure to have you on the call with me today, John, talking about this subject.
Well, it's a pleasure to be here, Dan. I look forward to it.
So we're going to start off, John, with an area that many people who are going through divorce are concerned about, and that is particularly in high-asset divorce cases, the possibility that their spouse, their partner, is hiding assets, and they won't be able to find that as they go through a divorce. So can you tell me what the most common types of hidden assets are, and maybe just a little bit about what you do to help find those assets?
Well, Dan, the most common form of hidden asset is cash, and that is also the most difficult one to trace. Frequently, what you'll notice is that somebody has a bunch of unexplained asset sales, or you'll notice that they have a bunch of unexplained withdrawals, and then you cannot find a corresponding deposit or corresponding purchase. And that's generally how you discover it. You have to go through all of the bank cards, the credit cards, the electronic funds transfers, any savings accounts, any brokerage accounts that they have, and you look for transfers or with cash withdrawals that do not have an adequate explanation. Some of the assets that people hide their stuff in, their money in, they'll buy a limited partnership, they'll buy some type of private investment where they don't think they're going to get a 1099 at the end of the year. Sometimes they will just deliver money to their friends. Some of it, unfortunately, does make it out of the country, so you're always interested if they've traveled extensively. Of course, some of the Caribbean islands are notorious for opening up secret bank accounts, and again, you look for trips there and for assets that may have been withdrawn from the community estate, but for which there's no adequate explanation as to why it was withdrawn, and that usually is eventually converted to cash and taken out of the country. So I hope that answers your question.
Would you normally work with a forensic accountant on that sort of thing as well, or do you look after all of this yourself?
Usually we go through a three-step process. I ask my clients generally to either sit down on their own or sit down with me and go over the bank statements, the brokerage statements, the credit card statements, the cash withdrawals, etc., and highlight things that they think are suspicious. I also look over and try to find things that I think are suspicious. If we find enough suspicious items or enough large ones, then I generally recommend that we hire a forensic accountant, usually a certified public accountant who has had an extensive auditing experience and fraud investigation experience, and then we start turning over records and working with the forensic accountant.
I see. What happens in a case where a couple shares a lot of personal property? How will the value of the property be converted into assets?
Well, the court has a number of different options. Of course, if the high personal value is things that are readily liquid, such as 401ks or cash in accounts or stocks or bonds or stuff like that, the court can divide them in kind. Husband gets XYZ%, or he gets this, and this asset, and wife gets XYZ%, and this, and this asset. Other types of property become much more difficult to value. I remember on one case that I had where the couple had bought hundreds of thousands of dollars worth of African art. This is very difficult to value. There are very few people that are familiar with appraising it. We contacted a number of different appraisers and never really could come up with a good appraisal. Eventually, the parties worked out an agreement to actually divide the African art in kind. Other types of personal property we're able to find appraisers for. I've done extensive appraisals on furniture. I've done it on other types of assets such as business assets. I've done it on other types of artwork or china, silverware, stuff like that, that a lot of this stuff really adds up in value. And so we usually look at trying to get an appraisal on it if it's of substantial value.
Maybe you can give us the distinction, John, between community property and separate property in Texas, and also tell me, why is separate property such a big issue in a Texas divorce?
Well, Dan, separate property in Texas is anything that you owned prior to marriage or that you acquired while married by inheritance or gift. Everything on the day of divorce in Texas is presumed to be community property. There is no presumption that you own property before your marriage or that you actually received a gift. If you cannot trace it or prove exactly how you got the property, then the court is going to treat it as community property and divide it as community property. The significance of separate property in Texas is twofold. First off, the court cannot divest a party of their own separate property. So if someone has a substantial inheritance or received a substantial gift, the court cannot take that away from the party. It is not subject to division by the court. The other significant thing with separate property in Texas is the burden is upon the party claiming that their property is separate to prove it, not by the normal civil standard of preponderance of the evidence, but they've got to prove it by clear and convincing evidence. It has to be documentary evidence, has to be an accountant, a forensic accountant, usually a CPA or some type of expert who analyzes the accounts or analyzes the asset, how it was purchased, and can trace it back to either the inheritance, the gift, or that you owned it prior to marriage. And if you cannot trace it by clear and convincing evidence, then the court at the time of the divorce is going to treat it as community property and divide it.
Right. Let's talk about business and divorce for a moment. Does each spouse have a right to a percentage of the business? In that case, you mentioned everything's treated as community property. So do they have a right?
If a couple acquired or developed or built up a business while they're married, then it is considered community property and it is subject to division by the court. As a practical matter, many businesses are really not subject to division. How do you divide a shoe store? How do you divide a grocery store? How do you divide a machine shop? How do you divide a radiology clinic? Things like that are hard to divide in kind. In those cases, the courts then and the attorneys expect to get some type of business evaluation done. This will value the assets of the business, look at the income of the business, look at the nature of the business, the regulatory environment that the business operates in, and we will get a professional opinion as to what a professional thinks that business is worth. Then the court will typically award that business to one party, usually the one that has operated it or been more substantially involved. They will assign a value when they award that to that party, and then they will give the other party what is called an equalizing judgment. They will say, and I'm just using round numbers here, if the business valuation comes out to be $1 million and the wife is the one who runs it, they will say, all right, we're going to award this business to the wife. we think that it's worth $1 million. We think that as a judge, I'm going to award the husband the sum of $500,000 as a judgment. I'm going to impose a lien upon the business, and I'm going to order the wife to pay off that lien at, say, $5,000, $10,000, $15,000 a month until the entire $500,000 is paid. So that's pretty well how the courts handle it. They either figure out a way that it can be divided in kind. Sometimes if you have Smoothie King, Subway sandwich shops, and stuff like that, the courts can divide the businesses and give one certain location to the other alternate locations. But absent some type of business that can be divided in kind, it's going to be awarded to one party, and the other party is going to get an equalizing payout on it.
John, I'm assuming as you're giving examples of these types of businesses that you've probably dealt with all of these types of businesses, from the small to large businesses. It's really important
You're
to have that
exactly
sort of experience.
right. I've had to get involved in machine shops, patents, turbines, turbos, injectors, jewelry stores, retail stores, you name it.
Well, this is where experience comes in, to be so handy, right? Because you kind of know the path, you know the path to follow, to identify the value, and you have a sense for it. It's something that experience, there's just nothing that replaces experience in this situation. So I'm mentioning this for the listeners. You should be looking for a very experienced family lawyer if you have any significant assets. Well, anytime you should, but particularly when you've got significant assets to divide or find.
I would agree. Many of these assets actually have hidden value that the parties are not typically aware of, and sometimes you have to hunt around the country to find an expert that can really give you guidance. I remember once I had a case involving an incinerator. I found one expert in New York City, and that was it.
Right. So what happens when, and I think you've covered this off, but let's just get clear about it. When, let's say both parties, the husband and wife, start a business together years ago, but one of them, left the business and went off to pursue something else. What happens, in that case with a divorce? How is it divided, and who gets the business? Is it different than what you just described?
The court is almost certainly going to award that business to the one that has been most active in the business, particularly as long as that individual is a responsible individual that seems to be running the business with a degree of integrity during the divorce process. Then they will grant a compensating judgment. We will have experts value the business. Sometimes we get 2 or 3 experts to actually value the business, and then the court will decide how much the other spouse is to be compensated. They usually start with a percentage of 50% on up to sometimes up to 60% of the value of the business. Then the spouse that is awarded the business is ordered to pay the non-owning partner or spouse their share over some stated time, usually the shortest time that the court thinks that they can order a party to pay it.
So when you say that the court, does the court actually value the business, or do you bring a value, you as a lawyer, and the other side, of course, would have their perception, the other lawyer would have their perception of what the business value is? How does that work? So each of you gets a valuation? Or?
Not typically. Sometimes we can both agree on a value either performed by my evaluator or once in a while the other side's evaluator. I much prefer to get an evaluator in early in the case. Then sometimes I've had other sides agree to use my evaluations. Sometimes they go out and hire their own evaluators. The court is not going to do any of the evaluation work themselves. They are going to listen to the testimony of the evaluators. They will also listen to the testimony of the parties, because sometimes these parties have a lot of insight into the business and the industry. They will also take into account what I call the intangible value or hard to measure value of owning a business, such as belonging to a country club, buying cars, being able to entertain freely, being able to travel to places that are very comfortable or enjoyable to travel to. They'll take all of this into account, and they will pick their own figure from the evidence they've heard.
I see. And so we talk about business, but what about the distribution of other assets? How does the court determine who gets what and
well,
when they're
in
selling
Texas,
it?
they use a very nebulous standard. Basically, the way the law reads in Texas, and I'll quote it now: the court shall divide the estate of the parties in a manner the court deems just and right, having due regard for the rights of the parties and any children of the marriage. We commonly refer to this as the just and right standard.
Mm-hmm.
Most of the time, the court is going to take into account about 15 different factors in figuring out what percentage of the assets to award to each spouse. They'll take into account any fault in the breakup of the marriage, any disparity in income between the parties, any disparity in education between the parties, any disparity between the parties on future business opportunities, any property that a spouse may have inherited. They will take into account the children. They will take into account any illness of a party, and almost any other thing that the court thinks is an equitable factor that it should weigh in deciding how much of the value it should give to each spouse. If everything is equal, the court in Texas is going to go 50-50. As more factors begin to favor one person, for example, if you have a low-income spouse or a person that has not been in the job market for a number of years, and they also do not have any formal education, and they also have some health problems, then the court is going to award that spouse an equitable division that goes up to roughly 60%, and the spouse that is the high-income earner is healthy and well-educated, they're going to award that spouse typically 40%. So the courts normally operate in a 40 to 60 range, with 50 being the normal if everything is equal.
And would it, if let's say you had a case where one spouse was a stay-at-home spouse and earns substantially less than the other spouse, or nothing at all, would that come into part of the equation in terms of figuring out?
That is definitely part of the equation, and in many cases, the stay-at-home spouse is a stay-at-home spouse because of the children. Now, the courts also weigh who gets custody of the children in the factor, but the court will definitely consider the fact that one person stayed at home. In Texas, we view that as being very supportive of the spouse that was able to go out and move into the job market or the profession and earn lots of income, so we want to justly compensate the spouse that kept the home front up.
Right. And what happens in a case where a couple starts out in young, going to university, one of them goes off to medical school, and they become a very successful doctor or some type of physician, dentist, like that, and the other person, maybe got a lower paying job and just stayed at that level forever. Does the doctor, dentist, whoever they might be, do they have to share their income forever after they get the divorce if they happen to get a divorce from that person? How does that work?
No, they do not have to share their income. Texas looks upon education as being somewhat of a personal trait. Cindy Crawford is a absolutely attractive person. She can earn more money than a lot of other 50-year-old women because nature was very kind to her. So they're not going to, when Cindy Crawford gets divorced in Texas, they're not going to award her spouse a portion of her future income. Same thing with a doctor, whether it be a man or a woman, because a lot of doctors now are women. the court is not going to impose upon their future income any type of burdens. They're free to take their income earning ability with them. The one thing the court will do is they will value the practice that the doctor has. And you find that some of the doctors, depending upon the circumstances, have some extremely valuable practices. I was involved in one a while back where the doctor actually had 4 other doctors working for him. He had all of the contracts with the insurance companies. He had developed all of the marketing skills. He had instituted all of the accounting. Basically, if that doctor had wanted to sell his practice and retire, he could sell it for a substantial sum, either to another doctor, or there are a number of groups around the country that will actually come in and buy up a doctor's practice and take over the management of it. So in that case, while the individual doctor is free to take his talents and go elsewhere, his business is going to get valued, or her business is going to get valued in the divorce action.
So what happens with 401ks or 403bs and pensions? How are they divided?
Well, the court determines the value. 403bs being the savings account that occurs when you work for a nonprofit, 401ks being the ones that you get when you work for a for-profit company, and pensions. The court will determine a present value on the date of divorce. And then they will divide the accounts at that time. They enter what is called a qualified domestic relations order, which is a separate order signed by the judge that awards a spouse that is not working for the company or the institution a portion of the account or the amount. It may be 50%, maybe up to 60%. Pensions get a little bit trickier because frequently an employee is continuing to contribute to the pension, and the estimate that you get from the company or the employer is predicated upon the fact that that person is going to remain in employment for the next, say, 10 years. If you're looking at a divorce from a 55-year-old woman that has been working with a company or a governmental institution for 30 years, she is probably, to get the amount shown on the little statement they send you every January, she's going to have to stay there another 10 years. So you have to figure out what the present value is, and we usually bring in, again, a forensic accountant, or there are several people around the country that are experts in valuing pensions, and they can come up and testify to the court that XYZ dollars is the present value of the pension, and then usually they will follow up and say, now, if you give the spouse that is not earning the pension XYZ percent, then they will be fairly compensated because the other person is going to have to work another 10 years in order to get the full value of it. And again, the pensions are handled by a qualified domestic relations order.
What about a couple that has a lot of money in IRAs? How are they handled in the divorce?
IRAs are much easier. They are handled by a transfer letter or letter of transfer. Sometimes the institution that is holding the IRA will simply accept a letter that I prepare, and I have both parties sign it. Other times, you run into institutions that require their own forms. And what we usually do when we see IRAs in a divorce, we usually contact the IRA holder long before the divorce is nearing the final stage, and we obtain those forms, and we go ahead and complete them so that the day the judge signs the final divorce decree, we can then serve that or send it out by certified mail to the holder of the IRA, and as soon as they get that, they will divide the account into 2 separate accounts and make certain that neither spouse has any ability to see what the other spouse is doing with their separate IRAs now.
I see. What about inherited, either property or money or gifts that somebody has inherited? What happens with that? Is it just treated as community property, or is it treated as separate property?
If you can trace it as your inherited property by clear and convincing evidence, then the court cannot take that away from you, and they must set it aside to you. If you cannot trace it by clear and convincing evidence, then the court is going to treat it as community property. And I have found over the years that in order to trace a lot of separate property, you really have to use a forensic accountant. The calculations get very, very detailed. I've seen cases where an accountant has prepared over 120 schedules going through looking at an account year by year by year, quarter by quarter by quarter, and determining what is separate property and what is community property. So it does get very complex.
Right. And even if let's say if somebody inherited a house, the upkeep of the house, that would have to be brought in as part of the determination of what the percentage of ownership is? And
no, not if they inherited the house. If they inherited the house, and particularly if they lived in it, the court basically looks upon that as where you were lucky you had the marriage did not have to pay rent. But they're going to, if you can prove it clearly, you've got the deed where it was conveyed to you by your mother or your father's executor, then it's going to be your separate property, and the court is not going to touch it nor take that into account in dividing property to speak of.
I see. Okay. Let's talk about prenuptial agreements for a moment. And I know that you do prenuptial agreements, and I also know that perhaps you have some experience in defending people who are questioning whether the prenuptial agreement should be valid or not. Is there some way of terminating a prenuptial agreement?
No, you cannot terminate a prenuptial agreement as such. In other words, once you sign a premarital agreement, you cannot send your letter, your spousal letter that says, I hereby terminated, I'm not going to live under it, or cannot tell the court, well, I terminated that. What you can do is the court looks at whether or not the agreement is enforceable, and the court, under limited circumstances, can refuse to enforce an agreement. Generally, for a court to find that they're not going to enforce an agreement, they have to find that the agreement was unconscionable when it was written. And they look at the total circumstances surrounding the execution of the agreement. For example, if somebody hands a party an agreement 15 minutes before a wedding and there are 250 guests sitting there, and they say to the party, if you don't sign this, I'm walking out of the church or the wedding ceremony, that may be unconscionable.
Right.
So you look at the circumstances surrounding the execution of it. And then you also have to look at whether or not a party signing it was provided fair and reasonable disclosure of the financial obligations of the other party, or if they didn't voluntarily waive it and waive in writing the right to get any additional financial information, or if they couldn't possibly have gotten it. You got somebody that hid some assets in a foreign country and you could not ever locate those. In those cases, the court can refuse to enforce the agreement. But a word of caution, because there are a significant number of cases out that say signing a dumb agreement is not unconscionable, and there's no reason to avoid enforcing it. And they point out in those cases that businesses, the New York Stock Exchange, brokerage firms, insurance companies, oil companies, frequently sign agreements that in hindsight were dumb. So if you
that's not an excuse then.
Yeah, if you sign a dumb agreement, you may end up buying it for life.
I see. Now, tell me about a postnuptial agreement, and when is it too late to get one of those?
Well, it is never too late to get a postmarital agreement, and I have done a number of postmarital agreements. I've had people that wanted to separate the majority of their financial affairs. They didn't want to be divorced. Sometimes they wanted to own a particular asset together but not be divorced. And you can go through and do what in Texas we've referred to it as a partition and exchange agreement, where you go ahead and divide up assets. Husband gets ABC, wife gets XYZ. There appears to be one difficulty in Texas with postmarital agreements, and that is what to do about alimony, or as we call it in Texas, spousal maintenance. In a prenuptial agreement, it is emphatically clear that you can waive your right to receive spousal maintenance. It is unclear at this time under Texas law whether or not you can do a postmarital agreement that will waive your right to receive spousal maintenance.
Well, let's end our conversation getting a little bit deeper into that subject. So can you explain what the difference is between spousal support, alimony, and court-ordered maintenance?
Yes, Texas is a community property state, and it always has been. It looks upon all property acquired while married as being more or less partnership property. Many of the other states do not. The other states that do not have community property developed years and years ago the concept of alimony. And in some states it's payable for life, or it's payable for a certain number of years. Their idea being that the working spouse typically gets all of the property that he or she earned while working. So to be fair to the other spouse, they ought to have to pay in the years ahead. And particularly some of the eastern states are notorious for having pretty onerous alimony. Texas did not have any alimony, spousal support, or maintenance or anything until about 20 years ago. And we came in with a form of it. We call it court-ordered maintenance. It is rather limited in Texas. Matter of fact, I'd say it's extremely limited in Texas because Texas basically expects two adults that are healthy to go both work and become productive members of society. But if somebody has been married for 10 or more years in Texas, they are eligible, if they're not able to earn a decent income, to get court-ordered maintenance. My general observation, while the law does not say anything about it, is it is what I call rehabilitative alimony. I think most judges look at a situation, parties, and they say, what is the shortest period of time that I can award a spouse in Texas court-ordered maintenance to assure that they get back into the job market as quick as possible? So if you have somebody that, say, had 2 years of college, when they got married, they stayed home and took care of children. 15 years later, they're getting divorced. If they're back in college, they have a degree plan. They can show the court how they're going to graduate and what kind of job they're going to get. They're probably going to get enough alimony to get them out of college, and that's about it. So,
well, people who are listening to our session, I want to remind you that John is in Texas, as he said a number of times. So if you're going through a divorce or contemplating a divorce, or you're recently divorced and you're looking for legal advice, I strongly encourage you to seek out a family lawyer like John, who focuses their practice in the area of family law and knows the subject inside and out. And I want to thank John for joining me today. And
thank you, Dan. I've enjoyed it.
Well, it's a pleasure. And I can tell you that he offers a high-quality service. I've been publishing Divorce Magazine for 20 years, and many of his colleagues in Texas sing his praises. So if you need help of a seasoned professional, I highly recommend that you check out John. And you can visit his website. It's www.john, K. Grubb, GRUBB.com. That's johnkgrubb.com. And I encourage you also to listen to some of our other sessions in the Divorce School. Tremendous amount of information to help you if you're, again, contemplating divorce, going through divorce, or recently divorced. Thank you again for your time, John, and thank you, folks, for listening. Take care.